I previously posted a number of videos dealing with Supreme Court cases Chambers and Carroll. There we established that if the police officer has probable cause to believe that a vehicle contains incriminating evidence and he stopped that vehicle on a public highway, he can search the car without getting a warrant. I will link the videos here above, and I encourage you to watch those first. And today we're going to deal with what's called automobile exception even more. But we're dealing with an RV, a mobile home. Is that more like a house, or is that an automobile and it still falls under the automobile exception? We're going to answer that question today in this video. This Supreme Court case is California versus Carney. And here the police officers receive information that somebody is exchanging marijuana for sex from a motorhome that's parked close by. So the officers begin surveillance of the motorhome. They see a youth go in, and an hour later he comes out. The police officers approach this individual, they ask him a number of questions, and the youth acknowledges that he just received marijuana. The police officers ask the youth to go back to the motorhome and knock on the door. When the door opens, Mr. Carney steps out. The police officers put him under arrest. One of the police officers, without consent and without a warrant, steps inside the motorhome and begins his search. He finds marijuana, scales, and other incriminating evidence inside the motorhome. Now, Mr. Carney makes an argument saying that they couldn't search his motorhome without a warrant. After all, the Fourth Amendment protects you against unreasonable searches and seizures, and it tells us that the officers must get a warrant before searching somebody's property. Now, the police officers rely on the automobile exception, which tells us that if they have probable cause to believe that a vehicle contains incriminating evidence, they can search it without getting a warrant. So in this case, we decide, is this motorhome more like a car or is it more like a home? The Supreme Court tells us that when the vehicle is being used on public highway, or if it can be readily used on the highway, the two justifications for the vehicle exception to the Fourth Amendment requirement of a warrant come into play. First, if the vehicle is not actually moving, it can be mobile within a turn of the key. And second, there's a reduced expectation of privacy in our vehicles because there are a lot of regulations dealing with vehicles as compared to fixed dwellings. So what do we take away from this case? Generally speaking, motorhomes are going to be dealt in exactly the same ways as automobiles. An automobile exception does apply to motorhomes. So here's a couple helpful tips when we're dealing with motorhomes. Maybe when you're parked, put the window coverings so it shows to the police officers that you're not going anywhere. Or you know those stabilizers when you're parked so the vehicle cannot be moved around? Put those down. If you enjoyed the video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.